Good afternoon.
Good afternoon. If I could reserve 5 minutes for...
5 minutes, yes, ma'am.
Good afternoon, Your Honors. Jean Harrison here at the Nashville Bar. I'm here on behalf of the Whitakers, who are the homeowners. This is a relatively small residential construction issue that has somewhat spiraled. Trying to bring some order to this. The genesis of this case is you have a builder who was hired by my clients to construct a home. There was obviously a dispute that blew up at some point, and a lawsuit got filed. The amount of money that was initially involved in that lawsuit was about $21,000 and some change, which is a pretty small dollar amount for a construction case. My initial dealings were not with current counsel, they were with another attorney. We went back and forth on this for a while trying to get it resolved. But at the end of the day, this lawsuit got filed. We filed an answer, and there was an attempt to get to some fairly early mediation to try to resolve it. Again, it's a small case. That mediation failed, and at that mediation it became very apparent the parties have very different interpretations of this contract, and excuse me, and hence here we are. This contract was drafted by Artistic, and it has a couple of provisions in it that are critical to the underlying issue that's involved. As near as I understand the facts as they currently are, because again, Your Honor, we have done zero discovery other than there was some written discovery that we supplied back to them. But my understanding is that Artistic is seeking a contractor's fee for work that it did not perform that was done outside the contract. The actual contract, which is in the pleadings here, is a little bit, well, it's a lot confusing. There is a provision on one hand that says that this is a cost plus job with a 20% contractor's fee. Then it says that there is a fixed fee with a specific number right after each other. There's also a second addendum to that contract that specifically says substantively the same thing, that this is a fixed bid or a cost plus job, but then it has a fixed contractor's fee. That's obviously a straightforward conflict. And considering that the issue now seems to be that whether the contractor is actually entitled to a percentage fee beyond what was in the contract, the issue then becomes, how do you interpret this contract? The contract also has at paragraph 8C a very unusual dispute resolution, and that is the genesis of why we're here. On the one hand, it says that any breach of contract matter goes to the courts, but it says if there's any dispute as to the interpretation of any provision in the contract, it goes to an arbitrator for determination. That obviously creates a setup where you're asking to determine how to essentially, one, how do you interpret paragraph 8C, which is who decides? Is it an arbitrator or is it the court? So that's problem number one. And problem number two is that we've got this dichotomy created where we're arguing over what these provisions mean. It is certainly true that this is a breach of contract claim. There's also a lien claim that was filed and some ancillary issues. But at the end of the day, Artistic is seeking monetary damages. My clients filed a very small counterclaim related to, I think, $6,700 worth of defective work. But now we're in the position where we filed, after the failed mediation, my clients filed a motion to compel arbitration. This is a case that is absolutely primed for arbitration and for a construction lawyer to resolve. It's exactly
so. What question then would you present to the arbitrator? What would you ask the arbitrator to resolve?
Well, the first issue is the issue of arbitrability itself. That's problem one. Because
But we know the answer to that question, right? Because unless the arbitration agreement provides that arbitrability is reserved for the arbitrator, the court decides that.
I would ordinarily agree, except for the language of this particular provision, which says if there is any confusion as to the interpretation of a provision, which would include the dispute resolution provision, because now that's an issue, that actually becomes an arbitration issue as well. So I do agree with you typically that you would expect to see an arbitration provision where it says determinations of arbitrability would go to the arbitrator, but in this particular case, by virtue of the drafting of this provision, they've set that particular issue in motion as well. So that's problem one. with this. And then problem two, of course, to answer your question, is that the arbitrator, in addition to deciding how this should shake down, it's going to be a threshold determination for the arbitrator to decide, what do the provisions mean? Is this a cost plus, or is this a fixed bid? Because if it is a fixed bid, this case is substantively over, because, again, this is a bit outside the pleadings, but my clients have paid all the fees that were due. So there's no other issue that would end it. If the arbitrator finds, no, that's not it, this is a cost plus and there's more to it, then that becomes, that would obviously go back.
So you're saying that the contractor here is trying to recover more than $94,675?
That's correct.
Okay.
So, and the issue appears to be that when there was, depending upon who terminated who, and that is outside the scope of this proceeding, but there was work that was done by my client subsequent to the home. The cost, of course, went substantially over. I'm sure you're stunned to learn that a house was not built precisely for the budget in Middle Tennessee, but when that house got built, there was a substantial amount paid beyond this, and he is now claiming entitlement to a cost plus on top of that. So that, Your Honor, is the essence of where we are today.
Yeah. And are we governed here by the Tennessee Arbitration Act or the Federal Arbitration Act?
It doesn't say, Your Honor, but what I would say is that...
Is there any interstate commerce involved here?
Yes, Your Honor. I mean, honestly, in a construction case like this, your materials are obviously going to come from every which way across state lines. It's certainly going to impute the FAA. I do believe, the provisions in this are substantively identical to a certain level. I think in this case, the TUAA is imposed when a party says that there is an arbitration clause and they want to invoke it, then the TUAA sets out a very similar process to the FAA.
So the alternative argument here is, well, even if it was in the scope here, and the court gets to make that call, that waiver. We waited too long to evoke arbitration. Why are we waiting to this point to evoke arbitration? Because the case has been pending, since 2023?
The case was filed in December 2023, Your Honor. It wasn't actually served until February of 24. I was actually out with a knee replacement, speaking of being old. And so I wasn't in, and I had been dealing with a different lawyer in the firm that Ms. Franklin was then with. We did a waiver of service, so we didn't actually get started on this until April of 24, functionally. And then we went to mediation. We were supposed to go in January of 25, so roughly 8 months. There was nothing substantive done in this case, Your Honor. And there's a long line of cases that are cited in my brief, and I'm happy to point it out. But essentially, there's been no waiver here of any meaningful rights by the other side. There's functionally, a small delay.
But there's been mediation and there's been discovery, it sounds like.
They served discovery on us, we responded. We have had no dispositive motions, no depositions, nothing. The only thing that's occurred is an early mediation, at which point we realized that there is a significant dispute over this, over the interpretation of how this is supposed to read, and that the amount of money is not what's in the complaint. And I think but the bigger issue here is, in order for them to claim that they had been prejudiced, again, the law very strongly favors arbitration, even in cases where, there's been some court activity involved in it. This, as I said, is absolutely what arbitration is designed to deal with. This is the quintessential kind of case for that. It is a residential dispute over terms of art that are, related to construction things, and the question is, is this cost plus? Is it fixed bid? And, who gets to decide that? By virtue of the agreement of the parties themselves, in the written document, it says any dispute as to the interpretation of a provision must be decided by the arbitrator as a threshold analysis. Does that answer your question?
It does. I'm still it seems to get a little circular here with that language, but I appreciate it's the contractor's language, so it's not your fault that it's circular. But, normally I would expect to see in an arbitration provision where the arbitrator gets to decide whether the dispute itself is subject to arbitration. You would say somewhere in there, any question of arbitrability is for the arbitrator.
I don't disagree with you,
Yeah,
Your Honor. Typically, that's
but I know
fairly standard.
that's not your provision.
I'm stuck with the provision
Yeah.
that I have, and, you know, this is a situation where the object here is to try to limit the limitless. Once they started asking for depositions and those things, that's when this got triggered. And I guess unless you have another question, I'll sit and wait for rebuttal.
Thank you, Ms. Harris.
Thank you.
Good afternoon.
Good afternoon. I'm Sydney Franklin. I'm from the Dixon County Bar, and I'm here to on behalf of my client, Artistic Builders. The issue on this case is pretty straightforward. I think it's been discussed fairly well by opposing counsel, but does this arbitration clause in this contract apply to this situation? And it's our position it does not. This case, as you noted, Your Honor, has been pending since 2023, although the defendant with the Whitakers were not served until early in 2024. It has been pending for a significant amount of time.
So, but what is your client's position on the plus component of it here? Is your client limited to recovering only $94,675, or is it cost plus?
Judge, it is cost plus, but that amount, if you look and examine that contract, is estimated at the time the parties entered the contract. It was an estimated amount. It is very clear, it states that it's estimated, and if you've ever constructed a home, remodeled a home, Your Honors may be fairly well versed with, you may think it's going to cost this. Once we get into it, if changes are made, those costs can rise exponentially, and especially during the time that this particular house is being constructed, which was right after COVID when prices skyrocketed with building materials. So it's our position that it was cost plus, and I believe with that estimated amount for what the fixed contractor's fee would be. And I believe that until this motion was filed, that opposing counsel believed so as well, which is evidenced by paragraph 2 of the counter complaint that was filed. Which paragraph 2 of the counter complaints, what the appellants in this case alleged as follows: on March 27th, 2022, the Whitakers contracted with Artistic to construct a single-family home on a cost-plus basis with a fixed contractor's bid. That was their position in 2024 when they filed their counter complaint. Now it is, well, we don't know which one it is. We don't.
Well, I know what, but I can tell you which one they prefer. They prefer the $94,675. But it sounds like to me, yes, the answer is yes, there is actually a dispute about how to read this contract.
Well, Judge, I obviously disagree. I don't believe that there is.
I mean, I know you're saying that's your reading's the better reading, and I get that.
Sure.
But I have to say, when I just sort of glanced at it, I thought, oh, okay, it is cost plus, but they've agreed in advance the plus will only be $94,675. What a good deal they negotiated. And it turns out, no, not so much.
And that was, again, based on the estimated cost
Yeah.
at the time that the
Okay.
contract was entered. But what's important here is I don't think that issue of construing that language is before the trial court. If there was an issue regarding the construction of this contract, either party had the opportunity to request that the trial court construe the contract, request a
Well, but no, I mean, do they have that opportunity? Because it looks like the parties are entitled to have that construction arbitrated.
They are.
I mean, I have never seen an arbitration clause quite like this. I'm not sure what to make of it precisely.
It is unique, Your Honor.
Yes, it is unique.
However, both parties, when they filed their pleadings in this case, and any pleadings that are in the record that is before this court today, have alleged a breach of contract. No one in the actual pleadings that were filed or anything that is supported by the record other than argument of counsel states.
Would you agree that this is a Federal Arbitration Act case?
I would, Your Honor, because the interstate commerce is
Clause,
involved,
okay.
yes.
And so, if that's the case, the Supreme Court, U.S. Supreme Court has told us that really we should always err in favor of arbitrating, sending it to arbitration whenever there's, so doesn't that sort of counsel in a case like this, you know, in there any question at all, we ought to send it on to the arbitrator?
That, in part, there is obviously a preference for arbitration where there's an arbitration clause, but the question then becomes, does the arbitration clause apply? Again, it's our position the arbitration clause here does not apply to the breach of contract claim itself. The practical application would be, let's go to arbitration to figure out if it's cost plus or fixed cost, then we're gonna let the arbitrator decide that, which is going to take some time. Then we're gonna go to the trial court to decide the actual breach. So let's go through a two-step system. Let's further extend how long this case is going to drag out.
But the parties contracted for that two-step system.
They did, Your Honor.
And probably should not have, but they did, you know.
And I don't disagree with you. And again, it's our fallback argument as well, as if this court finds that the arbitration clause does apply to this specific dispute, that the parties have waived the arbitration requirement here. There are several factors that this court has previously noted this court should analyze when determining whether a party has waived an arbitration requirement. And that the court discussed this in Altum versus Capital Records Group in 2020. And again, these are factors, which it's up to this court's discretion, obviously, how to weigh those factors. But one is whether the party's actions are inconsistent with the right to arbitrate. It's our position that filing an answer, submitting yourself to the jurisdiction of the trial court here, then filing a counter complaint in the same trial court, all without ever making a motion at that point to stay the proceedings, go to arbitration.
How does the uniqueness of the arbitration clause in this case factor into the waiver analysis? Because, you know, in a typical arbitration clause where you're saying, you know, we're sending the dispute generally to arbitration, I would grant you that, you know, filing an answer, participating in discovery, that might be waiver. But this looks like something where, you know, you could have an interpretation issue that came up well into the case. And in that case, you know, the arbitration or the contractor agreement seemed to say, we're going to let an arbitrator decide that.
Well, Judge, here, I don't think
That's a long question. That question make any sense at all?
I'm going to do my best to answer,
Okay.
Your Honor. I think here there was not necessarily an issue that arose on how to interpret this contract. At least, again, that's supported by the record or anything that's discoverable. There was mentions of mediation discussions. Obviously, those are protected by Rule 408. But when we filed this complaint on behalf of Artistic Builders, we put a very specific sum that was due, that we were alleging. It obviously with a caveat and other sums to be determined at trial, but there was a very specific amount of $21,000 and some change that was alleged. They were on notice that that was the amount, again, plus others to be determined at trial, as attorneys who draft complaints often include, and want to be able to maximize the amount that our clients can receive at trial. They were on notice of the exact amount that we were alleging my client was owed because of the breach. I don't think this is a situation, Your Honor, where all of a sudden, a year and a half into litigation, we are stunned by the amount because we believe now that you wanted cost plus or instead of the fixed rate. They were been on notice since the beginning of the exact amount that this lawsuit was filed over. So I think I hope that clarified a little bit.
Yeah, I mean, I guess the point I was getting at is your alternative claim is, well, if it's within the scope, waiver. And I guess your answer is, well, when you're analyzing waiver, the type of dispute that may be arbitrable doesn't or shouldn't factor into the waiver analysis. Is that fair?
That is fair, Your Honor. And again, the other factors are the degree of pretrial litigation. We've went into that. We've sent written discovery. We went to mediation. The opposing counsel stated then there was an attempt to schedule depositions and followed by the motion to compel arbitration. In our local judicial district, we're required to attend mediation before getting a trial date. It's a check the box in order to get the trial date. We checked that box. I believe we were all, at least at that point in time, gearing towards going to trial in the trial court. Which I think, even though there hasn't been a ton of pretrial litigation, I believe that factor weighs in my client's favor. The length of delay in invoking an arbitration right and seeking a stay, well, we've had a pretty lengthy delay at this point, which would be further extended if this court were to overturn the trial court in order that we attend arbitration, because we would have to line up the arbitrator. If the parties pursuant to this agreement can't agree on the arbitrator, which I don't think parties very rarely do agree, if we're at this before this court on an interlocutory, then we have to go to the American Association of Arbitration, select one, get on the calendar, have everybody's calendars lined up, have the arbitrator make a decision as to cost plus or fixed contract. Then we're going to go back to the trial court. Then we have to request the trial court to get us a trial date. Trial courts are at least 6 months out, if not a year out on a trial date. So going to arbitration is going to really delay these proceedings. The fourth factor is the proximity to a trial date. We don't have a trial. We never had a trial date, so I believe that factor would probably weigh in favor of the Whitakers. Whether the defendant seeking arbitration filed a counterclaim without asking for a stay. That happened here. I believe that factor weighs heavily in keeping this matter before the trial court. And again, the last factor is the resulting prejudice to the opposing party. It's our position my client would be prejudiced because, again, we're going to have to go through even more protracted litigation here, go before arbitration, then end up back in front of the trial court where we started. So, again, it's our position, Judge, that the arbitration clause number 1 is not invoked here because it is just a breach of contract claim. To us, really, whether it is a cost plus or a fixed contractor's bid, it's not really relevant when you have the exact amount in the complaint that is being argued about.
And the exact amount of the complaint exceeds the 94,675.
I believe that's contested. I think it may be, I'm not good at math, Your Honor, which is why I decided to go to law school. Unfortunately, we still have to do a lot of math. I do believe that it does exceed it, but again, that amount was based on the estimated cost at the time.
Right, yeah. And I understand your position is that's just an estimate and they were bound to pay more potentially.
Yes, Your Honor, and I think the contract states
Which an arbitrator could ultimately agree with you on that.
I would hope so. We end up there, Your Honor. But again, it's our position that everyone's been on notice here about the amount that's in dispute. Is it a huge amount of money? No. Should we have to jump through a million different hoops whenever we've been in the trial court and filed in the trial court at this point for almost 2 years? We've been filed for over 2 years. Then the Whitakers haven't been served for 2 years. But it's our position that this matter should just stay with the trial court. It was never an issue until after the matter didn't settle at mediation.
And counsel, do you agree generally with the timeline here? Suit filed into 2023, but it took a while to get it served.
It did.
And the only thing that's happened in the case, we've had an answer counterclaim, one set of discovery set, mediation.
Yes.
Okay.
Yes, Your Honor. We would request that this court affirm the holding of the trial court and deny their motion to uphold the denial of the motion to compel arbitration.
All right, thank you, Ms.
Thank you.
Franklin. Ms. Harrison, your rebuttal.
Very briefly, I want to talk a little bit about the contract. I would point to the court, paragraph 4 is really partially the problem here in this. It says payment of contractor's fee or the sum of 20% is to be paid as follows. And then it breaks down a schedule by which it gets paid on a draw basis, which is absolutely antithetical to a typical cost plus contract. You usually get a bill, 20% on top of it, and that you get this. It is certainly true in our counter complaint, paragraph 2. I did think that this was a fixed bid contractor's fee and a cost plus initially, and we certainly during the course of litigation, as Your Honor has suggested, come to realize that that is not what we are arguing about, and that is why we are here at this particular point. The other thing I would point out, and I want to talk briefly about this waiver issue. Number one, the trial court never ruled on the waiver issue. They just said this is not arbitrable. There's been nothing in the order from the trial court related to waiver. I would also point out that this isn't properly really before the court on this either, because the appellees in this particular matter didn't list it as an issue under 27B, and I would submit that the issue of waiver is waived, for lack of a better term, because they didn't timely bring it up in the way that they should have. It's not listed as a specific issue, and it shouldn't really be there. But to the extent that it is, and that there is this, I would point the court to take a look at their argument was Altum versus Capital Resorts, which is an unreported case from back in 2020 that this court decided that essentially spells out what you have to do to determine whether you have waived an argument. And I would point to the court that Altum isn't precisely as has been set forth. And in this particular case, the facts are very different. In Altum, those parties were actively litigating, dispositive motions had been filed. In this case, as the court is aware, and I think we're all in agreement, there was an answer and counterclaim and a mediation and some discovery that was responded to, and that's it. There's been nothing substantive. There has been no conduct by the Whitakers in any way that would have done anything that would have prejudiced the rights of Artistic in this particular instance. I mean, the aim of arbitration is largely designed to enforce the rights of what the parties have agreed to. I would absolutely concur that this is the strangest arbitration agreement I have seen in 30 years of practice as a construction lawyer. Never seen one like it. I don't really know what to make of it, and if I knew who drafted it, I might have words, but I think that this has set in motion a problem, because if you're trying to follow the contract specifically, and I am, and my clients are, and it said, if you have a dispute as to the meaning of any particular provision, then it goes to an arbitrator, but if you have a breach of contract, it goes to the court.
I agree. Of all the issues you would want to refer to an arbitrator, I mean, you've got a trial judge who's an expert in the law in interpreting documents, and you say, oh no, I don't want to take advantage of that. Let's send it to an arbitrator.
Typically, and that is why the law favors this. And you mentioned the Supreme Court case. This is first options very clearly would apply in this case, Your Honor. It is an FAA case, whether it's been really thoroughly briefed or not. I think we all agree that it is an FAA case. This is not a prima paint case. We don't have any issue with that.
Any forcibility, any threshold issues?
No, we don't have any of that issue here. This is a straightforward first options analysis. And frankly, at this point, I think it would have been appropriate for the trial court to simply say, I'm going to refer to arbitration, because if there's any doubt as to whether you should or shouldn't refer something to arbitration, the law is clear that you should always defer to the arbitration provision, and I think that's where we are. It is certainly an awkward positioned case, and I think it is primed for somebody with construction law experience to wade through, precisely for the reason that you've said. The court's expertise is typically in legal issues, and this is actually a weirdly factual one that will have legal implications. And I think it would be appropriate for an arbitrator to determine these issues. It may be a little unwieldy, but I do believe that if that threshold determination is made by the arbitrator, if it favors my clients, then I think the case is substantially over. If it doesn't, then you have a decision and we can go to the court and deal with it from there. So we would respectfully request that the court overturn the decision of the trial court and send this to arbitration. Thank you, Your Honors.
Thank you, Ms. Harrison and Ms. Franklin, for your arguments. We'll take your case under advisement. Please call the next case.